Hello, and welcome to this episode of the AML Clinic podcast. I'm your host, Michelle Clement, and in this episode, we are going to be deep diving into a case study following a law firm's journey to onboard a corporate client, the judgments they make, and the legal crossroads they face as gaps appear in due diligence. I'm delighted to be joined today by Ray Blake, a presenter, writer, trainer, speaker, and of course, co host of the Dark Money Files podcast, which has been running for 7 years. Ray is a true veteran with deep experience across banking, payments, and crypto. He served as interim MLRO and head of compliance and has worked closely with regulators as well as companies of all sizes. Ray, thank you for joining us today.
Well, it's an absolute pleasure, but you make me feel very old.
Was not my intention.
Okay.
Ray will help us unpack this scenario and share practical insights and offer guidance on navigating high-risk corporate structures. From initial checks to escalation decisions, this episode is a must for anyone involved in AML compliance. So, Ray, we have a scenario to work through today, so I'll jump right in with the facts. So, our UK law firm is approached by a consultant, Mr. T, who says he's acting on behalf of an overseas company called Five Circle Holdings Limited. I hope you caught my emphasis on the holdings because that's important. The deal is a £2 million commercial property purchase. Mr. T and Five Circle Holdings are completely new to the firm, but the property they're looking to buy is right here in our city, so there's a local connection. The purchase is set to go through a newly incorporated UK company called Five Circle UK SPV Limited. Five Circle UK SPV is a subsidiary of the parent company Five Circle Holdings. And from the very beginning, Mr. T makes one thing crystal clear: confidentiality is key. Ray, I'm going to pause here. I think we should start with the basics. What are the standard requirements under the money laundering regulations when it comes to identification and verification of corporate clients?
Yeah, well, first of all, we've got to understand who the client is, which corporate is the client. So in this case, the client undertaking the transaction or seeking to undertake the transaction is this SPV entity, I think, Michelle. So we have to identify the company. We have to know who the company is. We have to verify the company's existence and identity. We need to record its registered office and its place of business, if that's different. We have to understand the purpose and the nature of the relationship between that client and us. What is it that they want to do through our firm? We need to identify the law to which it's subject, so presumably UK law, but let's leave that as an open question for the moment.
Sure.
And we need to understand its constitution, so for instance, its articles of association, what they allow it to do and what they don't. We also need the names of the directors and the senior person responsible for managing the entity. And then, once we've done all that, we need to take reasonable measures to understand the ownership and control structure of the client entity.
Thanks, Ray. That's a really clear outline.
Just that, then.
Yeah, not much at all. Okay, so that raises another point I'd love to explore. The regulation talks a lot about identifying and verifying, but doesn't actually spell out a difference. The ELSA guidance, though, does make the distinction. So I've got a two-part question for you, Ray.
Yeah.
What's the difference between identifying and verifying? And why is that distinction so important when we're dealing with corporate clients?
Okay. Right. Excuse me, what's your name?
Michelle Clement.
I have just identified you as Michelle Clement. Now, if I'm prepared to take your word for it, then we'll have a lovely time knowing each other. You're Michelle, I'm Ray, everyone's happy. However, there might be all sorts of reasons why you might tell me that you're Michelle Clement, but you're actually not. I need to be able to rely on that identification of you to be absolutely watertight as far as possible. So I'm going to separately, using a method that doesn't rely on you, kind of get some verification of what your identity is. Now, if you've got officially sanctioned paperwork, you've got government ID, then that's good enough for me. I'll have a look at that. I'll inspect it and say, yep, I agree. I've verified you are Michelle. Now, of course, a company doesn't have a passport. It might have a certificate of incorporation. Depending on where it's incorporated in the world, that might look or be called something different. But in an ideal world, what I would be doing would be getting independent verification that doesn't rely on you giving me a bit of paperwork. I need to go and be able to check somewhere that what you've told me about your entity is in fact true.
Perfect. Really helpful, Ray, especially the distinction between naming someone and actually proving who they are.
Indeed.
And that becomes even more important when you're dealing with what we're going to find out to be layered corporate structures.
Oh, yeah.
Which brings us to the next part of our scenario. So in this case, Ray, the client is using an SPV to buy the property. So if
Sure.
we take a step back, could you please just tell us exactly what an SPV is and why they're commonly used in property transactions?
Yeah, absolutely. So an SPV is a special purpose vehicle. They're also sometimes called SPEs or special purpose entities. They don't have to declare themselves as such. I mean, we've got a title. We've identified that this company has called itself a name that includes SPV. It doesn't need to. An SPV is something you are rather than something you call yourself, if you see what I mean.
Yes.
So, what it is important. It's a legally separate entity that's created by a company to carry out specific and limited business activities. It's generally created to support something transactional, sometimes some merger or takeover activity, sometimes a purchase or a sale of part of a corporate entity or some other kind of property. And the idea is that it kind of insulates the parent organization from the risks of that specific transaction, or potentially that it gets it off of the corporate balance sheet. The idea often is that what we end up with is something that's bankruptcy remote, and there's a degree of insulation for a wider corporate entity. 9 times out of 10, that's what's going on, Michelle.
Understood. So SPVs are quite common. They're a common tool that's used in property deals,
Mm-hmm.
but they're of course not without their risks. And in this case, our SPVs, newly incorporated, has an overseas parent
Yeah.
and a consultant fronting the transaction. So from an AML perspective, what kind of red flags might an SPV raise, especially in a setup like this?
Okay, so immediately there are a few red flags here, Michelle. Now, a red flag doesn't necessarily mean that it's bad and we're not going to be able to do anything. It's just things that are going to need particularly close attention. The first thing, and you mentioned overseas ownership, because it turns out that this parent firm, Five Circle Holdings Limited, which sounds like a UK company, isn't one. And we'll come back to that. So we do have some multiple levels and layers in this structure. Now, complexity, corporate complexity and structural complexity is always going to be a red flag. Sometimes there are really, really good reasons for it. And if there are, that's absolutely fine. But we need to understand the economic and legal sense of structuring the entity or the transaction in this way. Because if we can't, that's going to be an issue for us. The allied point to that is there is opacity of ownership. We can't clearly see who are the driving minds and wills behind this organisation. I mean, it may well be that when we do some further research, that will become clear. But if if what we're looking at is a structure, even when we've seen through it, that looks designed to introduce opacity, then we need to think, well, is that a legitimate strategy to gain privacy in something which might be sensitive, or is there just no good reason for that level of privacy, absent a motivation that we might frown upon? And then there's the whole issue of jurisdictional arbitrage. This is a transaction that's happening in the UK from a company which doesn't seem to be otherwise concerned in the UK. So what's that about? Again, what's the legal purpose and the economic sense of doing that, and for the involvement of multiple jurisdictions? So for all of those reasons, I think we probably need to dig a little bit more deeply here before we go ahead.
I think I agree with you. So that's a really helpful breakdown, especially as SPVs can sometimes hide more than they reveal. So if we bring it back to the practical side for our law firm,
Sure.
if you were advising them,
Mhm.
what initial checks would you be telling them they should be carrying out before moving forward with this transaction?
Okay, so crucially, I think they need to understand the nature and purpose of the transaction. They need to know more about the ownership and control of the client, particularly who are the driving minds behind it. I think as a matter of urgency, we need to clarify the position of Mr. T,
Yeah.
who appears to be a bit of a third party or a consultant who's bringing this business to us. We need to understand his authority to represent the client and what his role overall is. We need to know that the role of the SPV and the other parties to the transaction, and specifically, why it's a UK entity that's getting involved here, where otherwise the client doesn't seem to have a UK footprint. And then more broadly, we just need to get an idea of the economic sense of this transaction and this structure.
Yeah, absolutely. I think that's key before we go any further.
Sure.
That's really helpful. If we bring it back to our law firm and see what happens next. So our firm begins its client due diligence process
Hmm.
and successfully confirms that the incorporation of Five Circle UK SPV by Companies House identifies that it has one listed director, notes that Five Circle Holdings Limited is the sole shareholder and thus the person with significant control, the PSC, obtains certified passport copies for Mr. T and the SPV's director.
Okay.
They also request a corporate structure chart,
Great
which they
idea.
receive. Yeah. But
Uh-huh.
the chart shows that actually it's lacking in detail of beneficial ownership. It's quite vague.
Okay.
It does reveal something, which is that Five Circle Holdings Limited is registered in the British Virgin Islands, the BVI.
Ooh.
Quite a bit to unpack there, Ray. So let's start with the fundamental first before we get to the
Yeah.
juicy bit.
Okay.
What's the difference between directors, shareholders, PSCs, and ultimate beneficial owners?
Oh, blimey. Okay. So the directors are the people who are formally and legally appointed, and they control and manage the entity on a day-to-day basis. They are officers
Okay.
of the company. Shareholders are the people who own the company as an asset, effectively. They're the people who own it. PSCs are people who, by virtue of a majority or a large minority shareholding, are deemed to be the effective controllers or directing minds of the entity. Now, so far, everyone in this explanation, directors and shareholders and PSEs, can be either natural persons, individuals, or they can be legal persons, corporate or other legal entities. The one exception to this is the UBO, the ultimate beneficial owner. Those are the persons who ultimately, the natural persons who are ultimately deemed to own and control the entity. And they have a special place in the anti-money laundering regulations because they are the people that you need to identify alongside the client itself.
Thank you. That's a really clear explanation of the different roles and why they matter so much when conducting due diligence. But of course, once you've identified those individuals or the entities, the next challenge is verifying them. And that's where
Yeah.
a lot of firms instinctively turn to Companies House when dealing with a UK company anyway. But the regulations, specifically Regulation 28.9 of the money laundering regulations, makes it clear that you can't rely solely on the register. So why is that, Ray? Why can't firms just depend on Companies House for verification?
Okay, well, there are several ways to answer this question, Michelle. The easiest one
Okay,
is to say Regulation 29.8 prohibits you from doing so. So you don't need to inquire any further, frankly.
sure.
But actually, there is a slight misunderstanding there. 28.9, sorry, only says that you can't rely on the PSC register
Yes.
at Companies House. You can rely on things like the INO1, the incorporation documents, and the confirmation statements that list shareholders, for instance.
Mm.
That's okay. You can absolutely rely on it. Maybe the less facetious answer here, though, and one that's potentially more useful, is that Companies House is a directory. Companies House is not a regulator. Until quite recently, Companies House didn't have anything that you and I might regard as reliable data standards.
Mhm.
Um, if you're quite selective about what you look at on Companies House, it can be a very, very reliable source of verification. But I would suggest it's not a reliable source often of primary information. So if you think back to the identification and verification I conducted on you, Michelle, I said,
Mhm.
"What's your name?" And you told me, and I said,
Mhm.
"Great, I've identified you. Now I need to verify you using independent evidence." Uh,
Yeah.
we're in a similar situation with a company. Um, Rather than simply saying to our client or their representative, "Oh, it's okay, we'll go and get everything from Companies House that we need to identify and verify you," you should either identify from Companies House data or verify using Companies House data, not both. So it's
Right.
highly acceptable for the client to provide all of the details, like the structure chart, like their incorporation documents, which you then go and check at Companies House. I often tell the story of my old economics teacher who talked to
Okay.
us about the use of statistics in academic papers. And he said statistics should be used rather as a drunkard uses a lamppost, for
Right.
support rather than for illumination.
I love that.
And it's exactly the same with Companies House. Use it for support, not to illuminate you in the first place.
Excellent analogy. I love that. Okay, so that'll be really helpful to a lot of firms because I think there's a lot of confusion around that point.
There is, yeah.
Um, absolutely. So does that mean, next question now,
Mm,
does that mean, so Regulation 28.3 states that the relevant person must obtain and verify the full names of the boards of directors.
yes.
It says more than that, but I've shortened it. Does that mean that firms actually need to obtain ID verification and address documents for all directors in a company,
No,
or
it
are there
just says
exceptions?
no, it just says you need a list of the names of the directors. On a
Yes.
risk-based approach, you might want to formally verify one or two directors, particularly if there are specific directors that are effectively steering the business on a day-to-day
Yeah.
basis and are giving you instructions. You might consider that's an appropriate thing to do.
Excellent. Thank you again. Another point of confusion for many firms.
Mm,
Right. Pivoting back to our law firm, a quick
okay.
recap on where we are in terms of due diligence. The firm has confirmed the incorporation of UK SPV Limited. They've identified and verified the sole director, noted the shareholder in PSC is the parent company, Five Circle Holdings. They've obtained a structure chart which reveals that Five Circle Holdings is based in the BVI, but the structure chart is very vague on beneficial ownership. At this stage, Ray, what
Yeah.
key information is our firm still missing that they should be actively pursuing?
Well, of course, buried in that information is primary evidence that you can't really just rely on Companies House because the stated PSC that we now know is a British Virgin Islands company can't be a PSC. According to the Companies House rules and according to the Companies Act, it cannot be a PSC. And yet you will find again and again in Companies House records that BVI or Marshall Islands companies are asserted to be the PSC. Well, that can't be the case. So what do we still not know? Well, there's quite a lot that we still don't know. We don't really have much insight into the ownership and control beyond the first level. Certainly, we're nowhere near identifying the UBOs, which remember have to be natural person owners
Absolutely.
and controllers. And we don't really know the purpose behind the structure and the transaction either. So there's still a lot to find out here.
Absolutely. We don't know where the 2 million's coming from, but I mean, that's a separate issue entirely
Oh,
at this point.
yeah, quite. Yeah, let's not even get started on that, shall we?
Yeah, let's not go there. Okay, so let's see how our firm gets done. So someone at the firm reviews the CDD on the file
Mhm.
and actually flags the following inconsistencies. As you said, Ray, Mr. T is not listed as a director, shareholder, or officer of either entity. So
Yeah.
what is he doing in this transaction? The structure chart shows Five Circle Holdings Limited is owned by Five Circle Capital AG, a Swiss company.
Oh, I say.
It's going to get a little bit complicated, so please do your best to follow along. So further research reveals that Five Circle Capital AG is 100% owned by a Panamanian trust. The trust is administered by a Liechtenstein foundation. The beneficiaries are described as private investment vehicles in Luxembourg. There are no named individuals. Ultimately, the firm cannot identify the UBOs.
Do you
The
know what,
fee earner,
Michelle?
right,
I tell you what, at
go
this
on.
point, I can hear people scrabbling for pens and papers and the rewind button.
Absolutely, I can as well. So, our fee earner does the right thing, consults the firm's money laundering reporting officer, citing the following concerns: Mr. T's unclear role and the lack of formal authority, the multi-layered offshore structure, the inability to identify a natural person as a UBO. Again, quite a bit to unpack here, Ray. But
Mm.
let's start with the fact that the firm cannot identify a natural person as the UBO. Why is this such a critical issue?
Well, I mean, it's the key foundation of client due diligence and of knowing your customer, and it's right there in Regulation 28. I mean, that said, Michelle, there are some caveats around this for situations in which it is difficult and may be considered unreasonable to kind of go beyond the call of duty. So if you read closely. Subsections 7 and 8, for instance, that's all about situations where you've exhausted all possible means of identifying a beneficial owner and what you should do instead. You've also then got to look at subsection 12 and 13 for those risk situations where that might not be appropriate and you might just have to move on.
Yes, absolutely. Great point that there are exceptions.
Mm.
If you were the MLRO in this situation, how would you proceed and what would be your rationale for doing so?
Whew. Well, first of all, I don't think I've exhausted all reasonable steps to identify the ownership
Yeah.
and control structure. So I would continue with that. I would do so before I allowed the firm to act on behalf of the client, or indeed Mr. T,
Mm.
because I'm not satisfied that we've properly met our legal obligations before acting until we do. I think I would be closely reading what the law required me to do. So for that, I'm going to go to Regulation 28, the one that requires me to identify and verify the identity of of the client and of the client's UBO. And I'm going to look closely at 12 and 13 and decide whether I've kind of, or I'm anywhere close, meeting the test of taking reasonable measures that are commensurate with the risks that I perceive in this case. Always with a keen eye on subsection 16, which says, be prepared to explain this to the supervisory authority.
Absolutely.
So I would want to be, making fairly well-reasoned decisions that were also quite well documented at this point.
Absolutely. I agree with you. The fact that the jurisdictions are quite high risk, BVI, the complexity, opacity point that you made, I think Regulation 33 would apply here. So you would
Right,
have to be conducting enhanced due diligence. And in the
definitely.
absence of that, I think you would fall short of Regulation 2816.
But I also
Absolutely.
think in respect of the specific entities that we've got here, I mean, we have a Panamanian trust and we have a Liechtenstein Foundation. In fact, that Liechtenstein Foundation is probably a Stiftung
Yes.
in there rather than a Treuhanderschaft, which is just showing off some of my expertise
Please
here.
do.
But if we have a generalist understanding of trusts, then we might be used to relying on things like the three certainties and separation of interests,
Yes.
which are common in UK trusts and structures that don't divert too much from UK common law. Well,
Mm.
with these types of entity that are coming into view now, we're not in Kansas anymore. Well, and actually, that's a bad example because Kansas trusts aren't in Kansas anymore. We're not in London anymore.
Yes.
And so there are things like, for instance, the beneficiaries of that Stiftung might not actually be identifiable people, might not even be an identifiable class of beneficiaries. It's
Yeah.
entirely possible with some of these structures that the trust is actually a purpose trust, which is effectively beneficiaryless.
Hmm.
All of which makes life a little bit difficult because in a trust-like situation, the list of UBOs includes the beneficiaries.
Hmm.
So all of this is a little bit difficult, Michelle. When combined with the fact that trusts, unlike companies, are not public documents.
Yeah.
And so there isn't often a registry where you can go and verify those entitlements. So I think I would be making sure that I had some overseas trust expertise to guide me on some of this.
Yes. Absolutely. So the next question was going to be, is there anything the firm can do to save this deal, given how complex it is and the points you've made about the fact that a lot of the information that we need they're not going to be publicly available.
Well, no, absolutely. But I maintain that it's probably possible here to undertake reasonable measures to get a reasonable amount of certainty. But it is reliant on the client to answer your reasonable questions. So we still don't understand the position of Mr. T. That has to be, worked out and evidenced.
Sure.
To take an example of the BVI company, we can't go to the BVI and get ownership details for that BVI entity. We've been told by the client who owns the BVI entity, but we do need to be able to verify that. Now, we can't do it by going to an open register because there isn't one. So what's the
Mhm.
next best thing we can do? Well, we can get the customer to give us a notarized copy of the incorporation documentation from BVI. Fine. We would note down the steps that we've taken to try and get
Yeah.
the best quality verification. So I mean, I certainly I don't think this is the end of the road in getting to act for this client. But I do think that the client needs to understand that they have to be, kind of more open and forthcoming if we're going to be able to demonstrate that we've taken reasonable measures.
Sure. Okay, I'm going to ask a question that's going to seem like a silly question, but I'm
Okay.
asking this because when I used to do inspections for the SRA, AML inspections, I have come across an occasion where I went to a firm and they actually submitted a DAML, Defence Against Money Laundering
Oh,
Suspicious
really?
Activity report, yes, when they couldn't complete due diligence. But that was more in relation to source of funds. But my question is,
Yep.
would this scenario justify filing a suspicious activity report to
Uh,
the NCA?
Not yet. No.
No,
No, absolutely not. I mean, your duty to report under poker is if you know or suspect a person is engaged in money laundering. I don't think you've got any basis for a reasonable suspicion of that at the moment.
absolutely, absolutely. Yeah, concur with that.
Good.
Okay, so let's move on to the regulatory landscape because you
Okay.
mentioned earlier on that there are some changes that have
Hmm.
occurred recently. What are the key changes that have been introduced? And they've mainly been introduced under ECTA, the Economic Crime and Corporate Transparency Act.
Hmm.
What are those key changes that firms need to be aware of, Ray?
Well, there are about a dozen key subheadings to ECTA, many of which probably aren't relevant for our discussion today, Michelle. But the key relevant one is that from the 18th of November 2025, directors and PSCs of UK limited companies will need to have their identity verified by Companies House or by an authorised corporate service provider when applying to be an officer in a new company or for a new company to be incorporated. After that date, at the time of the next annual confirmation statement, officers for existing companies will need to also provide verification. The equivalents of those for limited partnerships and so on aren't yet in place, but will be. There's some work going on now, and it will require more secondary legislation. But the vast majority of entities that we're dealing with are going to be, regular companies limited
Mhm.
by shares, and the rules are in place for those now.
Okay. What about the Register of Overseas Entities that came in August
That's
2020?
right. I mean, that wasn't an ECTA measure. That was the
That
predecessor,
was an
the First
ACTA,
Economic Crime Act.
right?
So hopefully, that's kind of fairly well established now,
Mhm.
and people are interacting with that.
Okay. So, in terms of the changes that have been brought in on the 18th of November 2025, do you
Mm.
think in the scenario that we just went through,
Mhm.
the new measures would have helped to mitigate the risks at all?
Well, not to any great extent, Michelle. And I mean, I don't want to be cynical about this, but there are a couple of reasons here. One of which isn't cynical at all. It's the fact that these reforms only apply to UK entities. So clearly, once the ownership goes outside the UK, they make not a blind
Mhm.
bit of difference. And that's certainly the case here. This has only got the barest footprint in the UK. This client. Um, but also, identification and verification is not a foolproof control, whoever
Yeah.
exercises it. The banks have had mandatory identification and verification of clients for 20 years, and there's no end in sight to fraud and money laundering that circumvents those controls in
Mm.
banks and payment firms today. So I don't see why we would expect it to be a silver bullet for Companies House when it isn't for the rest of the financial system, Michelle.
Absolutely.
But it
Thank
is
you.
important because if you're worried about heating in your house, the first thing you do is not go and fiddle with the thermostat. It's close all the wide open gaping windows, isn't it?
Absolutely. Absolutely. No,
Of which
great
this is
analogy
the key
again.
one.
Yes, definitely. So, in closing, what's your top piece of advice for firms when navigating due diligence for corporate structures?
Um, I would say know Regulation 28 very well. It is your friend. It gives you quite wide discretion in terms of the amount and quality of evidence that you need to be able to go ahead. Understand what reasonable measures actually means. Have a look at your firm-wide risk assessment, the type of clients and situations that you get involved in, and what you consider at a firm level some of the key exposures to be, and then consider what's reasonable on an individual case in the light of that wider assessment. Most importantly, ask yourself at every stage, does this make economic and legal sense in the light of everything else I know about the client, the transaction, and the situation as it's been described to me? And then record absolutely everything. Don't
Yes.
just record what you do or what you think. Don't just record what you know. Record everything on a 3-step basis. Fact, evidence, judgment. What do you know? How do you know it? And what do you judge from it?
Amazing. Thank you. Love that. The 3-step basis. Ray, thank you so much for helping us unpack the risks, the responsibilities, and the practical steps firms need to take when undertaking corporate due diligence. And that's it for today's episode of the AML Clinic. If you are a solicitor, compliance officer, or anyone working in legal risk, I hope today's discussion has given you something practical to take back to your firm. And if you found this episode to be useful, please consider sharing it with your colleagues who live in the world of nuance, risk, and razor-thin judgment calls. And if you've got a topic you'd like me to cover, I'd love to hear from you. Thanks for listening to the AML Clinic. Until next time, stay informed and stay compliant.